Good day, everyone. I am Anjali Imambak, and I am assigned to report Title 1, Obligations, Chapter 1, General Provisions, Articles 1156 to 1158. Let us tackle about Article 1156. Article 1156, an obligation is a juridical necessity to give, to do, or not to do. Now, let us tackle about the meaning of obligation. The term obligation is derived from the Latin word obligatio, which means a tying or binding. It is a tie of law or a juridical band by virtue of which one is bound in favor of another to render something, and this may consist in giving a thing, doing a certain act, or not doing a certain act. Manresa defines the term as a legal relation established between one party and another, whereby the latter is bound to fulfillment of a prestation which the former may demand of him. Article 1156 gives the Civil Code definition of obligation in its passive aspect. Our law merely stresses the duty of the debtor or obligor, he who has the duty of giving, doing, or not doing, when it speaks of obligation as a juridical necessity. And now, let's move on to the meaning of juridical necessity. Obligation is a juridical necessity because in case of non-compliance, the courts of justice may be called upon to enforce its fulfillment or, in default thereof, the economic value that it represents. Juridical necessity. It means the rights and duties arising from obligation are legally demandable, and the courts of justice may be called upon through proper action to order the performance. Action means an ordinary suit in court of justice by which one party prosecutes another for the enforceable or protection for a right or a prevention or redress of a wrong. For example, Gaya bought a refrigerator from Tito, but Gaya did not pay the refrigerator. If after demand, Gaya still did not pay, Tito can sue Gaya in court either to demand payment or for recovery of the refrigerator. Let's move on to nature of obligations under the Civil Code. Obligations which give to the creditor or obligee a right of action in courts of justice to enforce their performance are known as civil obligations. They are to be distinguished from natural obligations which, not being based on positive law, but on equity and natural law, do not grant a right of action to enforce their performance, although in case of voluntary fulfillment by the debtor, the latter may not recover what has been delivered or rendered by reason thereof. What are the essential requisites of an obligation? An obligation, as defined in Article 1156, is constituted upon the concurrence of the four essential elements thereof, namely, a passive subject, an active subject, object or prestation, a juridical or legal tie. A passive subject, called debtor or obligor, or the person who is bound to the fulfillment of the obligation, he who has a duty. The second one, an active subject, called creditor or obligee, or the person who is entitled to demand the fulfillment of the obligation, he who has a right. The third one, object or prestation, subject matter of the obligation, or the conduct required to be observed by the debtor. It may consist in giving, doing, or not doing. Without the prestation, there is nothing to perform. In bilateral obligations, the parties are reciprocally debtors and creditors. And the fourth one, a juridical or legal tie, also called efficient cause, or that which binds or connects the parties to the obligation. The tie is an obligation can easily be determined by knowing the source of obligation. To fully understand what is juridical tie, let us have an example. Gaia enters into a contract of sale with Tito, who paid the purchase of a GE refrigerator. Gaia did not deliver the refrigerator. Gaia is the passive subject or debtor, and Tito is the active subject or creditor. The object or prestation is the GE refrigerator, and the obligation to deliver is the legal tie or the vinculum juris which binds Gaia and Tito. This is also known as a unilateral obligation. That is, the obligation of the debtor to fulfill or comply his commitment, in this case, the delivery of the refrigerator. On the other hand, if Gaia delivered the refrigerator and Tito did not pay, then Tito becomes the debtor, who is bound to pay, while Gaia is the creditor who has the right to demand the prestation. Now let us understand the distinctions between obligations and contracts. So contract is the only one of the sources of obligation, while obligations have other sources like law, quasi-contracts, dilex or quasi-dilex. Contract is a bilateral obligation, while obligation is a unilateral obligation. All contracts are obligations, while not all obligations are contracts. Let's move on to the form of obligation. As a general rule, the law does not require any form in obligations arising from contracts for their validity or binding force. Obligations arising from other sources do not have any form at all. Obligation, right and wrong, cause of action, distinguished. Obligation is the act or performance which the law will enforce. Right, on the other hand, is the power which a person has under the law to demand from another any prestation. A wrong, cause of action, according to its legal meaning, is an act or omission of one party in violation of the legal right or rights of another, causing injury to the latter. Now, let's tackle about the essential elements of cause of action. Its essential elements are a legal right in favor of a person, creditor or plaintiff, by whatever means and under whatever law it arises or is created. A correlative legal obligation on the part of another, debtor or defendant, to respect or not to violate said right, and act or omission in breach of violation of said right by the defendant with consequential injury or damage to the plaintiff, for which he may maintain an action for the recovery of damages or other appropriate relief. If any of these elements is absent, the complaint becomes vulnerable to a motion to dismiss on the ground of failure to state a cause of action. A cause of action only arises when the elements occurs. At the moment, a right has been transgressed. It is to be distinguished from right of action or the right to commence and maintain an action, in that the former is governed by the procedural law while the latter depends on substantive law. The right of action springs from the cause of action, but does not accrue until the facts which constitute the cause of action have occurred. An obligation on the part of a person cannot exist without a corresponding right existing in favor of another, and vice versa. For every right enjoyed by a person, there is a corresponding obligation on the part of another to respect such right. Now, let's have an illustrative case. S rejected or canceled a contract to sell his property even before the arrival of the period in the exercise of the option to buy by the purchaser who has already made a down payment. Facts: S and B entered into a contract to sell, whereby B, after making a down payment, was given the option to pay the balance of the purchase price of a parcel of land. Later, S rejected the contract to sell, even before the arrival of the period, for the exercise of said option on the ground that the terms and conditions of the contract are grossly disadvantageous and highly prejudicial to his interest. S sent 2 checks to B in an apparent effort to return the down payment. S contends that the complaint was prematurely filed because at the time of institution of the complaint, B has yet to exercise his option under the option of buyer clause of the contract. Has B a cause of action against S for prematurity? Held, yes. All the elements of a cause of action are present. First, there is a legal right in favor of B, the right to complete the payment of the purchase price should he choose to do so. There is an obligation on the part of S to sell the subject property exclusively to B upon full payment of the purchase price, and there was a breach of S's obligation to sell the property. When S rejected the contract to sell, even before B could exercise his option to buy, notwithstanding that he had already made a down payment. The second one is S rejected contract to sell in no uncertain terms. The fact that the rejection or cancellation of the contract by S was not made judicially or notarial act is of no moment. It is enough for purposes of determining the existence of a cause of action that S has declared in no uncertain terms his refusal to be bound by the contract to sell. Such declaration, coupled with S's act of returning B's down payment, clearly indicates S's rejection of the contract to sell. Let's move on to the cause of action based upon a written contract. Actions based upon a written contract should be brought within 10 years from the time the right of action accrues. The accrual refers to the cause of action. Accordingly, an action based on a contract accrues only when an actual breach or violation thereof occurs. Therefore, the period of prescription commences not from the date of execution of the contract, but from the occurrence of breach. The cause of action resulting from breach of contract is dependent on the facts of each particular case. 1. In an action to rescind a contract of sale on installment basis for non-payment, the cause of action arises at the time the last installment is not paid. Number 2. When an overdraft agreement stipulates that the obligation is payable on demand, the breach starts only when demand is made. Number 3. In a contract of loan with real estate mortgage, whereby the creditor could unilaterally increase the interest rate, where the creditor foreclosed the mortgage when the debtor failed to pay the loan. The cause of action for the annulment of foreclosure sale should be counted from the date the debtor discovered the increased interest rate. Where the agreement to buy and sell was conditioned upon the conduct of preliminary survey of the land to verify whether it contained the area stated in the tax declaration, the right of action for specific performance arose only when the plaintiff discovered the completion of the survey. 5. The respect to money claims arising from a contract of employment which would prescribe in 3 years from the time the cause of action accrued. The cause of action would arise from the date the employer made a definite denial of the employee's claim. For prior to such denial, it is deemed that the issues had not yet been joined because the employee could have still been reinstated. 6. In an action for reformation of a contract, where the plaintiff alleged, among others, that the contract was one-sided in favor of Article 1156, the defendant, and that certain events had made the arrangement inequitable. The cause of action for reformation would arise only when the contract appeared disadvantageous. The last one is the nature of the product sold is a major factor in determining when the cause of action has accrued. For example, when the fuel oil is delivered in drums, a buyer readily assumes that the agreed volume can be and actually is. contained in those drums. So he is not expected to make a meticulous measurement of each and every delivery. In case of short deliveries, the cause of action will arise only from the discovery of the same with certainty. Injury, damage, and damages distinguished. The words injury, damage, and damages are sometimes used synonymously, although there is a material difference among them. 1. Injury is the illegal invasion of a legal right. It is the wrongful act or omission which causes loss or harm to another, while damage is the loss, hurt, or harm which results from the injury. On the other hand, damages denote the sum of money recoverable as amends for the wrongful act or omissions. And 2. Injury is the legal wrong to be redressed, while damages are the recompense or compensation awarded or recoverable for the damage or loss suffered. Let us move on to the existence of one without the other. There may be injury without damage and damage without injury. Proof of loss for injury. A wrongful violation of his legal right is not sufficient to entitle a person to sue another in a court of justice for the enforcement of projection of said right. As a rule, there must be in addition loss or damage caused to him by the violation of his right, but except for actual or compensatory damages, no pecuniary proof is necessary in order that moral, nominal, temperate, liquidated, or exemplary damages may be awarded. Number 2 is liability for damages of a person for exercising his legal rights. A person has the right to take all legal steps to enforce his legal and or equitable rights. One who makes use of his legal right does no injury. If damage results from a person's exercising his legal rights, it is damnum absque injuria, or the damage without injury. The plaintiff must establish that the damage to him resulted from a breach or violation of legal duty which the defendant owed to him. Otherwise, the consequences must be borne by the plaintiff alone. In other words, in order that the law will give redress for an act or omission causing damage, that act must be not only hurtful but wrongful. Let us have an illustrative case. Acts of importer contesting forfeiture, delay in the delivery of goods to highest bidder. Facts: S imported certain goods. The collector of customs declared the goods forfeited in favor of the government and ordered the sale thereof at public auction. The bid of Y was approved and the goods were awarded to him. Under the law, X has the right to have the decision of the collector of customs reviewed by the commissioner of customs, and from the decision of the latter to appeal to the Court of Tax Appeals, and from the latter's decision to the Supreme Court. X will be prejudiced if the sale is not set aside. Issue: is X liable to Y for damages from the consequent delay in the delivery of the goods? Held: such delay is an incident to the exercise by X of his right to contest the forfeiture and the sale of his goods. Now, let's tackle about the kinds of obligation according to subject matter. From the viewpoint of the subject matter, obligation may either be 1. Real obligation or personal obligation. In real obligation or obligation to give, or that in which the subject matter is a thing which the obligor must deliver to the obligee, or the personal obligation, obligation to do or not to do, or that in which the subject matter is an act to be done or not to be done. There are thus two kinds of personal obligation: A. The positive personal obligation or obligation to do or to render service, and B. Negative personal obligation or obligation not to do. Now that we are done with discussing the Article 1156, let us move on to Article 1157. Obligations arise from 1. Law, 2. Contracts, 3. Quasi-contracts. 4. Acts or omissions punished by law. And 5. Quasi-delicts. Sources of obligations. An obligation imposed on a person and the corresponding right granted to another must be rooted in at least any of the following sources. The first one is the law, when they are imposed by the law itself. Example, obligation to pay taxes, obligation to support one's family. The second one is we have contracts, when they arise from the stipulation of the parties. Example is the obligation to repay a loan by virtue of an agreement. The third one is the quasi-contracts, when they are arise from lawful, voluntary, and unilateral acts and which are enforceable to the end that no one shall be unjustly enriched or benefited at the expense of another. Example, the obligation to return money paid by mistake of which is not due. In a sense, these obligations may be considered as arising from law. The fourth one is we have crimes or acts or omissions punished by law, when they arise from civil liability, which is the consequence of a criminal offense. Example is the obligation of a thief to return the car stolen by him, and the duty of a killer to indemnify the heirs of his victim. The fifth one is we have the quasi-delicts or torts, when they arise from damage caused to another through an act or omission, there being fault or negligence, but no contractual relation exists between the parties. Example, the obligation of the head of a family that lives in a building or a part thereof to answer for damages caused by things thrown or falling from the same, and the obligation of the possessor of an animal to pay for the damage which it may have caused. Now, let's move on to the sources classified. The law enumerates 5 sources of obligations. They may be classified as follows. 1. Those emanating from law, and 2. Those emanating from private acts, which may be further subdivided into A. Those arising from licit acts in the case of contracts and quasi-contracts, and B. Those arising from illicit acts, which may be either punishable by law in the case of delicts or punishable in the case of quasi-delicts. Actually, there are only 2 sources, law and contracts, because obligations arising from quasi-contracts, crimes, and quasi-delicts are really imposed by law. Where the source of the obligation is a private act, the law merely recognizes or acknowledges the existence of obligation. Let's have an illustrative case. Liability of sheriff lawfully enforcing a judgment in an ejectment suit. Facts. A judgment was rendered by a justice of the peace court, now municipal court, in favor of X who brought an ejectment suit against Y, the owner of the house built on the land of X. Z, the deputy sheriff who executed the judgment, was obliged to remove the house of Y from the land according to the usual procedure in the action for ejectment. Issue. Is Y entitled to indemnify arising from the destruction of his house? Held. No proof has been submitted that a contract had been entered into between plaintiff Y and the defendants X and Z, or that the latter had been committed illegal acts or omissions or incurred in any kind of fault or negligence from any of which an obligation might have arisen on the part of X and Z to indemnify Y. For this reason, the claim for indemnity on account of acts performed by the sheriff while enforcing a judgment cannot under any consideration be sustained. The last article that I will be tackling about is the Article 1158. Obligations derived from law are not presumed. Only those expressly determined in this code or in special laws are demandable, and shall be regulated by the precepts of the law which establishes them, and as to what has not been foreseen by the provisions of this book. Legal obligations. Article 1158 refers to legal obligations or obligations arising from law. They are not presumed because they are considered a burden upon the obligor. They are the exception, not the rule. To be demandable, they must be clearly set forth in the law, the civil code, or special laws. Thus, an employer has no obligation to furnish free legal assistance to his employees because no law requires this, and therefore, an employee may not recover from his employer the amount he may have paid a lawyer hired by him to recover damages caused to said employee by a stranger or strangers while in the performance of his duties. A private school has no obligation to provide clothing allowance to its teachers because there is no law which imposes this obligation upon schools. But a person who wins money in gambling has the duty to return his winnings to the loser. This obligation is provided by law. Under Article 1158, special laws refer to all other laws not contained in the Civil Code. Let's have an illustrative case. Liability of husband for medical assistance rendered to his wife but contracted by his parents. Facts: X, by virtue of having been sent for by B and C, attended as physician and rendered professional services to a daughter-in-law of B and C during a difficult and laborious childbirth. Issue: who is bound to pay the bill? B and C, the parents-in-law of the patient, or the husband of the latter? Held: the rendering of medical assistance in case of illness is comprised among the mutual obligations to which spouses are bound by way of mutual support. If spouses are mutually bound to support each other, there can be no question that when either of them by reason of illness should be in need of medical assistance, the other is to render the unavoidable obligation to furnish the services of a physician and is liable for all expenses, including the fees for professional services. This liability originates from the above-mentioned mutual obligation which the law has expressly established between the married couple. B and C, not having personally bound themselves to pay, are not liable. Those are all the topics that I am assigned to report. Hope you have learned something. Thank you for listening and have a nice day. Bye!